Well, ladies and gentlemen, please join me in putting our hands together to give a very warm welcome to the one and only Teresa Cheng. Hey, all right. She is someone who needs a little introduction, the former Secretary for Justice, of course, and most important to me, she's my 老师, she's my professor. So, Teresa, once again, please put your hands together for Teresa. Thank you. Please take a seat. Okay. Thank you. So today is a fireside chat. It's going to be a little bit informal and chatty, hopefully. So welcome questions at any time. And our colleagues will be serving food and drinks throughout the occasion. So don't mind him walking around. I am Nick Chen, the director of AALCO Hong Kong Regional Arbitration Center. So today is our first of many fireside chats. I hope you can continue to support us. We have friends from the business community, technology community, legal fraternity, experienced arbitrators, students, interns, and our friends from IMO, International Preparatory Office for Mediation, right? 國際調解院辦事處就準備 office Dr. Sun， 俾啲掌聲 Dr. Sun Thank you. He's got this amazing, important task in front of him. But he's doing wonderful. Thank you so much. Okay, and our friends from the Law Society, Vice President. And I know some of you flew in specifically for this event. So explains the draw of why we, invited my professor. Thank you. Now, without further ado, I will start with some questions, and feel free to put your hand up. And I'm sure Teresa's up for the challenge. Now, with geotension risk of this decoupling and the rise of economies in the East, businesses and countries are stepping up their investments, cooperations, and sales and marketing activities in Africa, Middle East, and the rest of Asia. With more contracts, one can always anticipate more disputes and increased need for dispute resolvers. So parties to contract dispute may be from different countries and do not share the same legal system, culture, or even language. What dispute resolution forum would you recommend to contractual parties? Thank you. Over to you. Thank you.
Well, thank you very much, Nick. Can I just supplement to your invitation to questions? I always welcome questions, but I never promise that I'll give the right answers. But for this one, I think I would like to look at it this way. I think it's important, rather than to just say which forum, but to look at the qualities of the particular forum that I think will be suited for this particular political situation, this very challenging and some say unpredictable, some say predictable international world order that's going on. I think for a body to deal with this sort of international disputes, I think there are three fundamental requirements. I think the first one is that it must be established through collaboration. Secondly, I think it has to be a body that will draws on credibility to itself, or in a surrounding that has a lot of credibility for it to grow. The third thing, and I think that's very important given the countries and the areas that you're mentioning, is that this particular body will have to have something that is sensitive to cultural diversities. I think that those three are, in my view, the fundamentals of any forum or any platform that we're looking at. And as to the form, we are all thinking of arbitration, but we mustn't forget mediation being a very useful form, in particular in the current sort of diversity or polarization, however you put it, in the world's international legal order.
I feel pretty good with all that, meeting the three criteria at AALCO. But if I could say, if there are disputes specifically concerning countries or parties from Asia and Africa doing international deals, of course there are many dispute resolution centers out there, but with geopolitical tension, some have said, what if some centers are under the watchful eye of some governments? So would that affect how parties should think about what kind of, not necessarily which one, but what kind of dispute centers they should think about?
Well, I think, Nick, you've already sort of asked me a leading question just now.
Oh.
Very well led.
Thank you. Thank you.
But if I would look at it in this way, especially in the context of what you're asking. I think what I would like to say is that there are 4 types of arbitral institutions in the world. The first is what we call the local ones. Bodies that are set up by a group of people in a particular jurisdiction, and of course it grows and handles international cases. In Hong Kong we have HKRAC and a number of other institutions, GBM, the Maritime Arbitration Group, etc., etc. So these are what I would call the local arbitration bodies. There is another type which is a little bit more broader in terms of its space, and that is what I would call those set up by chambers of commerce. The Stockholm Chamber of Commerce has set up an arbitration body underneath it, and it has been doing very well. And of course ICC is another body that has a very strong arbitration community. So they are set up by chambers of commerce, and of course it will depend how inclusive it is in terms of their organization and planning. The third type is what I will call treaty-based international bodies. Treaty-based, like, for example, the International Center for Settlement of Investment Disputes in the World Bank. That's treaty-based, the Washington Convention. We also have, in the international law, you mentioned state-to-state disputes, the ICLOS, the International Tribunal for Law of the Sea. They're all treaty-based established body. And I think they probably represent a very high credibility and a very high collaboration effort of various states. The fourth is actually your body, Nick, and that is a body that I would call intergovernmental international body. Because AALCO, as if I say a few words, you should supplement, more. The Asian African Legal Consultative Organization. It's an intergovernmental international body that is very unique in the world because it is the only body that covers the cultural diversity and legal traditions of African and Asian states, and I believe 47 of them.
That's right.
And so they set up regional arbitration centers. And these regional arbitration centers are actually intergovernmental regional arbitration centers. It's not a local body. It's not set up by a group of businesses under the context of chambers of commerce. It is more or less like the treaty-based type of bodies because it's intergovernmental and under AALCO a number of Asian African states. And so I think we're very proud to have you leading this particular organization, I think here in Hong Kong, because it completely meets the 3 criteria I mentioned, established through collaboration, because all the states have to agree before they set up a regional arbitration center. It has certainly credibility because it involves a number of states and is established. The particular one we have here is the one that established in Hong Kong, which of course has a lot of strengths for arbitration and dispute resolution. And I think importantly, and this is the very unique thing, that is being sensitive to cultural diversity, because it has 47 states from around Asian and African countries. It will be able to understand and will be able to chip into concepts of policies on how you're going to perhaps conduct a particular case in a way that is not entirely westernized or adversarial, but perhaps a mixture of that. And I think that is what I believe makes AALCO regional arbitration centers, in particular the Hong Kong one, very useful.
Thank you, Teresa. And to supplement that, our head office of AALCO is in the middle of Asia and Africa. And our head office, the building is staffed by diplomats from the 47 countries. So it's truly country neutral. So that's why, a lot of people say this is perfect for investor-state dispute.
And I think Belt and Road
Indeed.
Related issues. Actually, how many centers are there, Nick? Let
Well-
me start doing the questioning.
Oops. Now, we have 6 regional arbitration centers, but of the 47 countries that are members of AALCO, over 80% of them are active members of the Belt and Road Initiative. A lot of them are also RCEP countries. So we have Japan, we have Singapore, and many other states. Some are not members of New York Convention, in fact. So I think that's quite helpful. You have 193 countries, right, recognized by the UN. And how many countries are now members of the New York Convention?
174.
All right. Thank you. Give her a hand. See, I knew I asked the right person. I was going to say 172. All right. What went on behind the scenes, former Secretary for Justice, if you're allowed to say? A lot of countries must have fought for the honor to be recognized, to have the AALCO set up there, a dispute resolution center, a regional one in their place. If ours is regional, then it's hard to have one right next to us as regional, I would imagine, right? So I know for a fact others have made the move for it. How did this happen?
Well, it is a central government initiative, actually, because Hong Kong, of course, is only part of China, and it is China that is a member of the AALCO organization. And I think with the support from the central governments, in particular, I must say with the Ministry of Foreign Affairs, being very active in helping us to pursue that. It allows us to actually make it successful and get the consent of all 47 states to agree to set up a regional arbitration center here. And I think that I can't of course divulge anything that's being negotiated at the time, but I think one of the attractions, and I remember back in 2016. When I was aware of the AALCO training that China had done, the China AALCO Exchange and Research Platform, that was to me a very important perspective, because there you will be able to meet hopefully diplomats and officers who may now be only officers, but may one day become the minister
Chief
of
Justice, yeah.
something,
Yes.
and or even the leaders of a particular state. So therefore, at that point in time, under the auspices of the Asian Academy of International Law, of which I was one of the founding member, we signed with them with this body, CAERP, to bring the AALCO training to Hong Kong. And that's when I realized the importance of AALCO. Not only is it important, I think, in the current context, but if you look back into how China has been involved in AALCO back in the time of our Premier Zhou Enlai's time, you will see that that's one of the main international bodies that China has been involved in, and very, very, very early on. So I thought, it would be good to be more involved, for Hong Kong to be more involved, because it will illustrate the one country, two systems very well. So therefore, when I became Secretary for Justice, I saw this opportunity to try and bring this to the central government and see whether they will support it, and thanks to them, they were very supportive, and through them we were able to negotiate with the other states to agree to for China to have a center, and of course within China they chose Hong Kong, and I think we're very fortunate to have that here. And as you mentioned just now, we are actually not far from another such a center, one in Kuala Lumpur. That was, in fact, the first one that was set up, if I remember correctly.
That's right.
But I think we were able to explain that Asia being so large, and there is the north and the south, or the sort of the southwest and the southeast type of regime, we're able to do that. And another thing we also brought on, which was at that point in time one of Hong Kong's policy, and that is to promote law tech. And I think that also helped us to secure the consent from the states, show that we are not just providing another arbitration center, but something that's added on to it. And I think that is one of the things that your rules are providing for, isn't it?
Indeed. I know the chairman of IBRAM's here. Do you want to say a few words?
Thank you, Nick. Thank you, Teresa, for giving me this opportunity to speak about EBRAM. EBRAM, we are an online dispute resolution mediation center, and we are a law tech company. Our founding members are the Law Society, and also the BAR, and also AAIL, the Asian Academy International Law. And we are a non-profit making body, and our objective is exactly what Ms. Teresa Cheng has just said, is to use high tech to bring our legal service as well as our dispute resolution service to the next level, so as to be in line with the National 14.5 plan to have a digitalized nation, including all our existing really good services that we've been doing, dispute resolution, arbitration, mediation, legal services, and take them to the next level. And thank you again. It was all Ms. Teresa Cheng's effort at the very start to make this happen. And then when we have AALCO, and thank you, Nick, also for giving us the opportunity to collaborate with AALCO, because AALCO's online platform is powered by EBRAM, and we're going to work together and try to bring this to create more products for our users, not necessarily to only lawyers, but also any users of our law tech products.
And I met James here today, Jim, from Hugh Dickinson, and he said he had previously set up an Asia-Africa or China-Africa desk. Do you guys see a lot of opportunities between Asia and Africa?
Yes, this was at my previous firm. It was an internal business interest group, it was a China-Africa business group, made up principally of disputes lawyers in Southeast Asia and in Africa, principally South Africa, where my firm had 3 offices, and those offices shared business with alliance offices in other countries in Africa. But we could see that there was a well-established flow of business from mainland China and other countries in Asia to Africa, supported enormously in more recent years by the Belt and Road Initiative. And as disputes lawyers, we could see that disputes were inevitable in this business, but we were mystified as to where those disputes were going. And so that was the reason for the group. But we could see considerable interest amongst our clients in dispute resolution. So we had monthly discussions. And other firms have done the same. We were not alone.
Thank you, James. So I think what we want to do is not just wait for the disputes to happen. Ideally, they don't happen, right? Okay, to some of the business people here, ideally don't happen. Lawyers, okay, we feel the same. But we want to help facilitate the deal. So Professor have always been championing deal making and disputes resolution goes hand in hand. So we're hoping through an organization such as ourselves, working under the auspices of 47 countries, we can help mobilize and connect countries, people, businesses to do business and avoid disputes. So what makes Hong Kong so special as a dispute resolution hub, Professor?
This is my very rehearsed answer, but it's genuine. First, we have a very good legal regime. Our arbitration ordinance, our mediation ordinance, and we also have the apologies ordinance, which also helps people to resolve disputes in various forms. So that's a very important legal regime. Secondly, we have a very good and independent judiciary. No matter what some of the papers say, our judiciary is really, really one of the best in the world. And from my own experience, when I was doing various cases in various parts of the world. So I think we're very lucky. So that's our second trump card. And the third one actually is you guys, people here. I think the people in Hong Kong are very international and able to really grasp with new ideas. And with dispute resolution, you have to be up to date. And I think, for example, this week there is a lot of activities from various international bodies and ICC having conferences here in Hong Kong. And there are a number of other events that are happening in Hong Kong this week. And we become a cluster, a hub for for all these people to gather around. And therefore the people, the litigation lawyers, the experts, and the parties themselves become more sophisticated, I think that's a word, when they come to deal with disputes, and more creative in that sense too.
Question for our Vice President of the Law Society. How many lawyers are there in Hong Kong and from how many jurisdictions? I can ask the past president if you don't answer it.
Well, totally we have 1,500 foreign lawyers. We
Right.
have about nearly 13,000 solicitors.
As in foreign lawyers with
Foreign lawyers
foreign qualified,
practicing
yeah.
is 1,500. Just over 1,500.
And how many firms do we have? Law firms.
995.
Terrific. And so, people practice Islamic law as well as Sharia law. Lots of good lawyers.
Finance, yeah, they've got for people who do not finance but structuring firms in order that they're compliant with the Islamic principles. Yeah, they do that as well.
Are lawyers in Hong Kong, interested in supporting businesses going to Africa, you think?
Yes, definitely. Yes, I think they're very broad, and it's not just the large firms. There's many firms, all sizes, that have, from my experience, have clients from Middle East, Africa, Asia. So yes, it's not exclusively to a large firm. As you get in London, Hong Kong's much more global.
Can you pass the mic to the person behind you? Dr. Hong, he was the chief representative of a Shanghai government in Hong Kong. So can you, maybe share your perspective on how companies, businesses in China, governments in China can use Hong Kong as a springboard to do business in Africa?
I think, first of all, just like what Teresa said, Hong Kong has its unique advantages, and also I think the credibility has to be built over a long period of time, and which we have earned that. So, but it's not easy though, because there's a lot of arbitration centers in China as well, and also they also can go to Europe or some other places. So, I guess the availability is, of course, the first condition, but the next one is probably a little bit more promotion, and it's. I think now I've never used arbitration myself. Okay, so even though I'm a businessman, luckily there was either no dispute or disputes too big that I just forget about it. But what I'm saying is it's, from what I heard from my friends and also my law professors, it's really that you can tell the difference when you start to use their services. And I think that's that's what Hong Kong should do. That's what Hong Kong have been doing, which is really showing our professional services and also reaching out. In this room, everybody is knowledgeable about either the law or the other world. But unfortunately, out there, I think Africa, to a lot of people, seems to be a very far place if you're as an ordinary person on Hong Kong streets. So these kind of things, maybe, yes, with the Belt and Road, with Chinese company are going there a lot, but Hong Kong, I'm not sure. So, but some of our friends are going there, right? So we begin to see that. So I think promotion, demonstration of professional works, and then maybe a few more franchises.
Thank you, Whitman. So, briefly, we'll be planning a trip to Africa. So, I'd like to take some of you with us. Now, back to Teresa. Is common law here to stay in Hong Kong?
Yes, definitely. The presidency has said that, made that very, very clear. Has actually referred to common law being staying in Hong Kong twice in his speech last year at the 25th anniversary. So, I mean, we all have to make it loud and clear to some of us, to some of the other people who haven't heard this particular point and still wondering whether the one country, two systems will continue to stay. I mean, he made that absolutely clear. So I think we can all be very confident that common law is here to stay in Hong Kong, and that's one of the biggest advantages for one country, two systems.
Malvin behind you is going to graduate with first honors from Chinese University of Hong Kong. So common law is here to stay. So nobody worry. But I mean, you know, young people are very smart. They also want to learn about civil law, learn about Chinese laws, and certainly encourage you to do so, right? In terms of law tech, you've been a great proponent in developing law tech in Hong Kong. Where do you see are the opportunities and challenges? Or if you think about generative AI, ChatGPT, do you have any thoughts on that?
Well, I think technology is going to be here to stay, especially after the COVID. Everybody now is so used to having online meetings and rather than traveling. So it is definitely going to stay. And I think it's important because I think if you look at trading, we've got chambers of commerce here. If you look at trading now, for example, some trading firm, one or two big trading firms, have sort of gone down in size because there is a new way of trading, like the Taobao, the eBay, and all these have actually changed the way the supply chain or the consumer market is changing. And that's all online. That's something that's e-commerce. Currency-wise, I'm not talking about the stages of Bitcoin, but our WeChat Pay, our Alipay are just the norm. You know, when you go to mainland, I only take my phone. You don't need anything else. Everything is there. So that's a very important thing. And the third thing I think is, as I said, after the COVID, it changes the way we live and the way we operate. And everybody now has their sort of screen or whatever at home ready for any online meeting. And I think therefore with technology, if you think about trading, small businesses first, not just the major ones, one of the things that I know, for example, GBM has been looking at is to use blockchain, because once you have one platform for trading and use blockchain technology to sort of quote unquote codify and record all the transactions, it will make dispute resolution a lot easier. You forget about all these problems with discovery, you reduce them a lot, and it will be a lot quicker. And I think that's one of the big things that the law tech is working on. And I hasten to add, I use this opportunity to add, not just to advertise for GBM, but people they fail to understand what is online dispute resolution as opposed to dispute resolution online. People think that if I do everything via email, if I have a particular Zoom or Tangxin Huiyi, then it means it is ODR. It isn't. You go and speak to Thomas. Thomas will explain how their platform works. It's actually everything is online, and that has a secluded line, and that's what matters. And the data being stored in the right place become also very important. As I do international arbitrations, I've had cases where because the data of Gmail, for example, is stored in the US, one of the parties that was before me end up having to face the RICO claim in the US because that's a jurisdictional link. So all these things in the international context become very important on how to plan, and therefore I think the law tech development, both in terms of ODR and also developing more on blockchain, is important. I think in China, for example, Tianjin is already trying out to use blockchain for their small financial transactions. And I think, again, it is definitely going to be here to stay.
Professor, under your leadership, Hong Kong has contributed to the development of the APEC ODR framework. Can you share with the audience here what do you think about that?
The APEC ODR collaboration framework is actually very important, and this is again where the APEC recognizes the importance of ODR, especially for MSMEs. And so they have a specific committee, and they developed this collaborative framework, and then they have then designated specific bodies to do these ODR that meets their criteria. And I think the first three, actually, interestingly, all from China. One is CTEC, the China International Economic Trade Arbitration Commission. One is Guangzhou Arbitration Commission. The third one actually is GBM, based in Hong Kong. And I think this illustrates how actually the whole of China in particular are looking at the importance of using ODR law tag in order to resolve disputes. And that has been a very important thing, and I think we need to work on that to bring more cases using the ODR platform that Hong Kong has developed in order to resolve disputes for MSMEs.
Thank you for that. Could you share with us often a misconception about the Congo case or any other memorable case you'd like to share with us?
There are many misconceptions about many things in the world.
Indeed, indeed. So, let's get you another get you a glass of wine first.
You have to get me a lot of glass of wine before I start telling you more stories. But you mentioned the Congo case. I'd always like to mention these two cases together. In fact, now there's three. The Congo case, of course, the DF hemisphere versus the DRC. That Congo case really establishes, it doesn't need a case to establish, but it needed a case to establish that Hong Kong's state immunity has to be in line with the central government, and it's not for us to decide anything else. Very simple, straightforward answer, because we're part of China, and of course state immunity is something that belongs to the state and hence the central government. So that in a way was what the DRC was famous about, and China practices absolute immunity. So that was state immunity or sovereign immunity. The next case, round about that same time, I happened to be doing another case called Hua Tianlong. Well, it's a long name, but if you say the Hua Tianlong, you can find that case. In that particular case, I established another, well, again, it's a principle that's been there for a long time under common law, and that is called crown immunity, meaning a court cannot, or meaning the king cannot be sued, I think, if I put it that way. And as it develops, it means the parliament and the relevant ministries. And so therefore, unless there is a statute that say a particular individual or company can prosecute or sue, well, not prosecute, sue is the right word, sue a particular, the government, then you can't do that. And that's called crown immunity. And that was established in Hua Tianlong. Then there is another case called well, again, I just mentioned the name of the entity involved is China National Coal. China National Coal case, I was also involved. That one I think was in 2017 or 2016. That one, we established that a state-owned enterprise is not allowed to enjoy immunity, crown immunity in that particular context. Not sovereign immunity is a different thing. There, a lot of Westerners and not people outside of Hong Kong get very confused. So can SOE have liability? And why is it Hua Tianlong say that in that particular case, that particular body, which is the Guangdong Dalaoju, the salvage body of the Guangdong province, cannot be sued? And the distinction is this. SOE is state-owned enterprise. Guangdong Dalaoju, which is the Hua Tianlong case, that particular entity, the salvage body of the Guangdong province, is what we call a public institution. It is a 事业单位. And because it's a public institution, its direct control is the Ministry of Transport. And therefore, it is part of the Central People's Government. And for that reason, it enjoys crown immunity. A state-owned enterprise does not enjoy crown immunity in Hong Kong or state immunity outside of China. They can be sued. And interestingly, I was just having dinner a few days ago with someone from SASEC, and I reconfirmed that with him. And he actually said that that is absolutely the position. So state-owned enterprises will be just another company, albeit sort of state-owned, as it were. So I think those three cases has caused a lot of misconception, but you have to remember two types of immunity: sovereign immunity and then crown immunity, which is only in the common law jurisdiction. And within crown immunity, you have to remember the state-owned enterprise doesn't enjoy any immunity per se, but the public institutions is like the ministry and therefore enjoys crown immunity.
Excellent. Henry?
Oh, this is Henry. just a practitioner for particular low tech and legal tech and fintech. Just on the third point, I think that's very interesting. But may I just clarify? When you just mentioned the state-owned enterprise does not enjoy the immunity outside China, but does it enjoy the immunity within China? Because that will be an enforcement issue as well, right? Because for anyone try to, let's say, just bring in, let's say, arbitration with the state-owned enterprise, because the next question, thing about enforcement, is it, will you be able to enforce against the state-owned enterprise, against the SL, the state-owned enterprise within China?
My answer to you is definitely yes. Legally speaking, it must be correct that you can enforce it, because they don't enjoy any of the immunities. They're just another enterprise.
Even within,
within China or outside China.
Okay.
So in Hong Kong, they can't claim Crown immunity. Outside of China, in my view, they can't claim state immunity. Now, I should say there may always be a little bit of exception. For example, that particular state-owned enterprise suddenly has been called upon by the state to do certain acts of state, in which case those may well attract sovereign immunity, but not in their daily activities, because their daily commercial activities are just any other company. Public institutions, 事业单位 is a very different category of fish. It's sort of within the ministry itself, and so therefore it is part of the ministry and therefore enjoys the sort of immunity that we're talking about.
But the Crown immunity or state immunity, that could be waived, right, overseas. Because, like, for example, I came across cases, like, particularly, some of the questions which the enterprises, they may ask, right, is it, they may put in the immunity waiver in the commercial contracts when they enter into, like, investment contract, let's say, with the SOE or that be...
A very interesting question. You can almost write, or we can organize another talk on that particular subject. But in Hong Kong, it has been established through, actually reinforced in the DRC case, that immunity has to be waived before the court. So arguably, the contract doesn't help you. Arguably. But a lot of other cases and other countries actually recognizes the waiver of immunity in the contract. So I think the answer is, as any lawyer would say, it depends.
Thanks very much.
I have a question for Nicholas Ho over there, who's a very, very famous architect. Nicholas, I saw you on TV in the Middle East with the chief executive, I think. Can you share with us what's the vibe over there? Are there opportunities for lawyers here to resolve their disputes? And maybe in the industry, do you use a lot of arbitration over court disputes?
Well, thanks for that, Nick.
Thank you.
I think there are definitely a lot of opportunities for professional services. I think Middle East right now is looking for high quality professional services that has international standards.
We're all here already.
To go into the region.
Yes.
I think Riyadh in Saudi Arabia is more interesting in a way because it is still very up and coming, and they require new standards. If you look at the growth of the financial market in KSA right now, it's been growing exponentially, and their partnership with the Hong Kong Stock Exchange has been very prolific as well. So I think Hong Kong lawyers with a common law background have a very strong advantage in Saudi Arabia. And obviously in Abu Dhabi, UAE, in Dubai, it's a slightly different story because it's actually very mature. In UAE, it's like Singapore of Middle East, basically. So the approach would be slightly different. But I do believe that Middle East is a huge business opportunity for Hong Kong services industry. It's interesting you mentioned EBRAM and also ODR at APEC. I'm still the APEC Business Advisory Council representative for Hong Kong, China. So at APEC, we also discuss ODR and EBRAM. We have very strong support from DOJ back then, from James. Thank you for that. But it's very difficult for us to get the MSMEs to use them. And it's a great initiative. It's great that we can get 21 economies to agree on a common standard. But the real issue is there's no adoption at the APEC region. It's not just digital literacy readiness issue. It's not just cross-jurisdiction issue. It's not just common education issue. I do believe that the sort of low-hanging fruit for EBRAM would be e-commerce or online small, very SME merchants. Those would be very easily adoptable if we work with big e-commerce platform to get that sort of term or rule inside their standard contracts. Would that be something you think or Teresa would think it's a good way forward for eBRAM to be more adopted globally?
I see a eBRAM director taking notes here, so thank you, Nicholas. We have a few more minutes. Let's open the floor for questions. Otherwise, I have one more question, which is, how do you write a good arbitral award? But any burning questions first? Want to give everyone a chance? Emil? Yeah.
I just have a quick question.
Mike,
I was
please.
just looking at the poster.
Yes.
There's a statement saying the replacement of the standard dispute resolution clause. What is that difference compared with a regular clause saying signing in China that we should have when there's a dispute, the arbitration should be in Hong Kong using a Hong Kong distribution resolution center? What will that be different?
I want to introduce you to my deputy director, Dennis. You want to say a few words?
And actually, our standard arbitration clause is the unique features we have using our online dispute resolution, which is help parties to save costs and help to conduct the proceeding more efficiently.
So by default, it's ODR,
yes,
unless you put in our other optional clause, which says we don't do. If you don't want to do ODR,
yes,
there's a clause you could add in. But we provide it as an option.
We also respect parties' autonomy, that the parties can change our rules to suit their needs. So that's another feature. And of course, we have an interim measure arrangement that you may have heard about from our Department of Justice. And then we are the only one is the National Organization Status Arbitration Institution that we can help party to seek this kind of interim relief from the mainland People's Court in China. So that's our key features of attracting parties to adopt our clauses, to my understanding.
So if you go to your court and wait for the decision to come out, or go to some arbitration centers that are not specifically qualified, we are qualified, then if you came to us, you could, the day you came to us, we start a proceeding, you could go to the mainland Chinese judges, courts, and ask to freeze assets and evidence, so that you don't need to wait a year and a half for the case to finish and everything's gone. Roy, you have a question? Thank you.
Yeah, Nick, just a comment.
Thank you.
We
Thank
represent the Hong Kong General Chamber of Commerce. We are general committee members.
Thank you.
Very glad that we're here today to learn about AALCO and to meet Teresa Cheng.
Thank you for coming.
I think for our chamber, I can see that at least 3 of our committees would be interested to learn more about AALCO. Namely, we have an Asia-Africa committee, and it will soon be named Asia-Africa Middle East committee.
Thank you.
And our SME committee and also the China committee.
Thank you.
So Nick, I think we can
I will follow up.
touch base.
Thank you.
afterwards.
Okay.
Thank you.
I think that's very encouraging. I think for the Hong Kong General Chambers of Commerce already have those committees. One of the things, in answer to the question, why use this particular clause? And I share a story that I think it was told by some lawyers who are negotiating contracts, and sort of one of the last clauses is the arbitration clause. I call it the champagne clause. But anyway, one of the things that they said is that when they were trying to negotiate an arbitration clause, usually they would say, okay, if it's a Chinese company, for example, they would say, oh, let's go to CTEC, Beijing Arbitration Commission, Shanghai Arbitration Commission, etc. And then sometimes the other side would say no. So they would then try, okay, what about HKRAC? What about SIAC? And they still tend to say no, because if you remember how I explained, they are the local bodies. So far as they are concerned, they are local bodies. But then as soon as it goes to the treaty-based, it's not every dispute needs to go to a treaty-based organization. But when they tell the other side that this is an intergovernmental body, that actually makes them twig. and they will think, okay, sometimes maybe the company of the other side actually belongs to one of the African states who's a member of AALCO, or maybe the next door neighbor is a member of AALCO state, and so they're a little bit more comfortable. So I think when it comes to Asian African disputes and Belt and Road type of disputes, that's where I think it will kick in a lot more easier than to sell what they would call, well, it's okay, it's very reputable, but it's still a local body. And I think that has been the feedback from some of the lawyers who were doing transactions when they said that they might therefore end up arbitrating in London, which is probably, so far as the Chinese and the African parties is concerned, that would not be their first choice. So that's a sort of war stories that people have told me.
Peter?
Quick comment regarding the interim measures about how good it is. And I think, as far as I know, Hong Kong is the only place outside of mainland China in the whole world they can have interim measures against Chinese companies. So I would have thought that if you're an African company with a Chinese counterpart, Hong Kong is probably the best place in the whole world to have an arbitration.
And also, I suppose the Chinese company prefer to do it here too. So it's a win-win.
Absolutely.
Okay, please join me in putting your hands together for the one and only Teresa Cheng, our professor. Thank you. Should we take a group photo if you want to sit over there?
Thank you so much.
Thank you.